Hello, my name is Karen McNulty Enright, and I am a partner at the law firm of Costello, McMahon, Burke Murphy. I have been practicing law for approximately 25 years in the area of personal injury and medical malpractice. Today, I will be talking to you about taking and preparing for a defendant doctor's deposition. Point number one is researching the doctor before you take his deposition. The defendant doctor in a medical malpractice case is one of the key witnesses. In order to prove your medical malpractice case, you have to prove that the defendant doctor deviated from the standard of care. Therefore, his deposition will be key in proving up your case. Before you take the defendant doctor's deposition, send a rider to the defense attorney. And in the rider, you will want to request a copy of his entire file. Now, what does this mean? It means requesting all of the records he reviewed. It means requesting the bills that he charged. It means requesting everything he has published that has to do with any of the medicine that you will be discussing. In addition to the rider, you will also want to do your own investigation on this doctor. Use Lexis and Nexus and Google and find out where he's lived, who he's lived with, what type of properties he's owned in the past, if there are any gaps in his curriculum vitae, if he went out of the country for a while, or if he's licensed in different states. All of this information will help you prepare for his deposition and help you get to know what type of person he is. The second point is to make sure you have a full copy of all of the medical records in advance of the deposition. When I say a full copy of the medical records, I mean the records that the doctor relied on when he was treating for the patient, including any and all records from any other institutions that he relied on, and any films. In addition to that, you will want to request a copy of any notes that he took. There have been a number of times that I have requested notes in advance, and I'm told that the doctor didn't keep any notes, only to find out at the deposition that he had pages and pages of notes, which makes sense. Anytime a doctor is treating a patient, they're usually taking notes. The notes can be in the form of a text. They can be in the form of an email. They can be part of an electronic medical record, or they can be handwritten notes. I've received notes on copies of Post-it notes or tabs. Whatever form of writing of notes this doctor has, make sure you get them in advance. And once you have a full copy of all of the records and all of the notes, you will want to do a timeline and organize all of the records in a fashion from the time that your client first saw that doctor until the last time your client saw that doctor. And make sure the timeline that you form with your client coincides with the records that you have. This will make taking the deposition more organized and more helpful to you in understanding the medicine. My third point would be to make sure you know the medicine. Now, before you filed your lawsuit, you sat down with your expert and he outlined the deviations from the standard of care and helped you understand, more likely than not, where the doctor had performed malpractice. Before the deposition, you will want to research the medicine. Sit down with your expert again and make sure you know every part of the body that you will be discussing, whether or not you're dealing with an aortic aneurysm or a failure to diagnose cancer or some type of bone injury. You'll want to know that type of medicine. What I find helpful is to sit down with the expert and use the films that were taken of the patient, or use diagrams, or have the doctor draw a diagram, or use something to help you visualize the type of problem or the type of area, whether or not it be a surgery or a diagnosis that the doctor was looking at. You will find on the internet there are a lot of times where these types of procedures, especially surgeries, are videotaped. And through the video process, you will be able to understand the exact area in which the doctor is working. My fourth point would be to set goals for the deposition. When you start your case, you have certain areas in which you feel the doctor deviated from the standard of care. Before you take his deposition, make sure you have certain goals. What do I want to get out of this doctor? What can I have this doctor admit? If the doctor won't admit to A, B, or C, will he alternatively admit to D, E, or F? Doctors sometimes give you more than what you're requesting. Use that to your advantage. So start with a list of goals you hope to get not only from this doctor, and if he doesn't give it to you, maybe one of the nurses will, such as a failure to diagnose a problem in the emergency room. The goals for the deposition of the doctor would be to ask him what the certain standards would be of the emergency room. What are the protocols when a patient comes in? Then go through your goals with the doctor. Your goals would be, did the doctor comply with the standards and the procedures set forth in the emergency room? Did the doctor do this in a timely manner? Did the doctor correctly diagnose the problem? Have these goals for each witness, but start off with the defendant doctor. My fifth point would be to remain calm during the doctor's deposition. Doctors are on the defensive, obviously, when you're suing them for malpractice. That doesn't mean that has to put you on the offensive or put you in an uncomfortable place. Know that going in there that doctor will be defensive. You might want to start off by evening the playing field and start off with some terms. You each need to come to an understanding as to what the doctor meant when he was using certain terms. So go through the vocabulary of the medicine with the doctor at the beginning of the deposition, so you both have a clear idea of what an aneurysm is, what an aortic aneurysm is, how you treat an aortic aneurysm, or how you diagnose an aortic aneurysm. So for each type of medicine that you're going to be asking the doctor about, make sure you're using the same vocabulary. And if the doctor, in response to one of your questions, starts talking about a term or an area of medicine that you're not familiar with, ask the doctor to define what he means by that type of procedure or that medication that he's giving, and have the doctor give you a clear definition. This will help the deposition go along more smoothly when he understands that you are not on the attack. In conclusion, I hope that you have found this video helpful. I have been a member of the ISBA for the past 25 years, and I am currently the chair of the tort section. If you would like to know more about torts or taking depositions, please visit the website at www.isba.org and look at our section council. In addition, the ISBA offers a quick reference guide for taking depositions and Supreme Court Rule 213. Thank you.